Hello? Let me turn his volume up. Hold on 1 second. I'm trying to. Can you see if I got this? I got this volume up, right? Okay, now I can hear. Is she saying something to me? Oh, I'm muted. Maybe she ain't saying nothing to me.
Thank you. Okay.
Oh,
Can I get your name, please?
Juanita Washington.
Okay. And what are you here on? Thank you, Fred.
The court case number?
Yeah. What are you here for?
You ready for the court case number?
Yes.
205214.
Repeat that for me, please.
205214.
I2. It should all be numbers. Numeric.
Yes. 2052.
Oh, 5-2. Okay. And what's the case about? What's the charge?
It's a small claims case.
Let's see. Hang on just a second. I'm trying to find your case.
Okay.
Okay, I'm going to go ahead and mute you for a minute so I can figure out where your case is at. I don't see it on the docket. Okay?
Okay.
Hang on. Ms. Washington?
Yes.
Actually, your case was just set for an in-house review. You weren't really set for a hearing. I just spoke to the supervisor in the civil department, and she said they will be getting back with you as soon as they get a hearing set. It's just for judge's review today.
Okay, because it says hearing on the paper that I have, it says notice to appear, and it says hearing for small claims today at 8:45.
Okay, what I'm going to have you do is call the civil department and you can talk to the supervisor there. Okay?
You'll stay on with the judge, or what do I do?
No, hang up from Zoom and just call in on the telephone to 734-941-4463,
Okay.
and then extension 211. That's the supervisor. Just talk to her, okay?
Okay.
Thank you.
Okay. Thank you. Bye-bye.
Bye. Good morning.
Good morning.
What case are you here on, please?
I'm here on two cases. The first one is number 20-2747 GC.
Give me the name, please.
Oh, sure. United Lab versus Nationwide.
And who are you here for?
I'm here for the defendant, Nationwide.
Okay, so Christine Lewicki, you're in for her?
Him. Yeah, I think
Him?
Christopher. Yeah.
Christopher, sorry, I only see
Oh, no
part of the
worries
name.
at all.
Okay. And let me just get you marked so the judge knows who you are. Hang on just a minute.
Thank you. And then the second case I have is also with the same plaintiff attorney, Mr. John Betts.
What's the case?
That one is CarePoint and Z-Ride versus Farmers Insurance.
Okay, and you're here for Cinnamon Plonka?
No, that one I'm here for Jeffrey Peach. The defendant is Farmers.
Okay, we show Cinnamon Plonka as the defense attorney on those two. That's
Can
all right.
I give you the case number? There might be more than one CarePoint
Okay.
Z-Ride. The case number on that one is
2027.
20-2819.
Okay. Okay, I see that. And the other one?
The United Lab case is 20-2747.
Okay, so that's the one we just talked about.
Mm-hmm.
Okay. All right, I'm going to put you back in the waiting room for just a few minutes.
Sure.
Okay? Thank you.
Thank you.
Jamaica Willingham?
Good morning, it's Jamesia.
I'm sorry.
No, you're fine.
Jamesia, are you the attorney for Farmers?
Yes.
Which case is that, please?
Case number or caption? There are two cases, CarePoint versus Farmers, case number 202765 GC. And then the second case is Z-Ride versus Farmer, case number 202766 GC.
Thank you very much.
No problem.
Jamesia Willingham. Okay, thank you.
You're welcome.
I'm going to put you back in the waiting room for just a few minutes, okay?
Okay, thank you.
Thank you. I was just going to tell you, it looks like I got the first 5 for Mr. Betts all lined up. And then it looks like that's all he's got. Yes. I'm just going to verify this one here. It shows Auto Club, but I got him in there too. Let me verify that. That one was not connected, so I'm going to bring in Mr. Betts, and the first attorney judge is on United Lab versus Nationwide. 2747 is the last four of that case. And she's on CarePoint and Z-Ride 2819. The first one is United Lab, case number 202747. The attorney's last name is
Good morning, John Betts here.
Good morning, John. Good morning, Judge.
Good morning.
Alice Fabishevsky on behalf of the defendant Nationwide.
So where are we at?
Well, on this one, Your Honor, plaintiff did submit a demand to us. However, we have an underlying case with the claimant himself, Dwayne Hunt, pending in the Oakland County Circuit Court with Judge Phyllis McMillan. We have had a great deal of difficulty obtaining any discovery in that case. And just last Wednesday on May the 12th, and also there's a co-defendant, it's a combined first and third party case. Both defendants, we had motions to compel granted against Mr. Dwayne Hunt, the claimant here. We've not been able to get enough information to verify his any eligibility for benefits. We do have an order now compelling his deposition within the next 30 days and compelling the plaintiff's answers to all our written discovery within 21 days. And
Okay.
After that point in time, we may be posturing for a motion to dismiss. There's also the one deposition we have been able to take is of the vehicle owner who denied that he had any permission to use the vehicle. So we're also considering a potential motion for summary disposition regarding non-permissive use. So there are very big questions about his eligibility for benefits. At this point, we would just request enough time for us to resolve these underlying issues.
How much time do you think you need?
Probably 60 days, Your Honor, based on that order, and then the time to prepare and file motions.
Mr. Betts?
I don't oppose that, Judge.
So let's just say adjourn pretrial for at least 60 days out.
That's fine.
Thank you, Judge. Yes, that would work well.
All right, and you two are on another file together, aren't you?
Yes, Your Honor. John,
What
I'm
one's
covering
that?
for Jeff Peach on the CarePoint and Z-Ride Anita Webb file.
All right, so you want to do Z-Ride versus Farmers?
Correct. Thank you, Judge.
All right, Z-Ride versus Farmers, your appearance.
John Betts for plaintiff.
Alice Fabishevsky on behalf of defendant farmers.
And where are we at on this one?
My understanding on this, Judge, is that Mr. Betts and Mr. Peach have agreed to facilitate this matter, and it's scheduled for this Friday. So perhaps an adjournment of 30 days on this? Does that work for you, John?
Yeah, that's fine. Yeah, we anticipate that facilitation will resolve not only Anita Webb's case, but the underlying provider case or two cases.
Here's what we're gonna do. We'll set this on our no progress docket at least 30 days out. So that way it just automatically gets dismissed unless somebody files something.
That sounds good, Your Honor.
Understood.
Okay, does that take care of it for you two?
That's it for
I
me.
know Mr. Betts has other files, but I mean, the files that you two are both on.
Yes, correct, Your Honor. Thank you.
All right,
Alice,
thank
I
you,
have
Joe.
another one with your office with Michelle Endres. I didn't know if you were covering that also.
I am not, John. I'm not sure if Michelle herself is or someone else, but it isn't assigned to me today.
Okay.
So Paula, who's next for Mr. Betts?
The
Thank you.
attorney's name is Jamesia Willingham. I'll bring her in. And she's
What's the
on,
file?
it's CarePoint and Z-Ride, the other two of those.
Okay, well, we got a problem because I don't have another CarePoint Z-Ride. I have CarePoint versus Farmers. I've got CarePoint versus Farmers again. But I only had one Z-Ride file, and that was Z-Ride versus Farmers.
That's the other one that she's on.
I just did Z-Ride versus Farmers, Paul. I only have one of those.
There was another one that had CarePoint as the first plaintiff and Z-Ride as the second plaintiff. That's the one Ms. Bevazuski was on.
That's correct. The one we just disposed of was 2028-19.
So Mr. Betts, which file are we doing now?
Well, the two that are ready to go are CarePoint versus Farmers and Z-Ride versus Farmers 2765 and 766. Same attorneys, same accident. They're both provider cases.
All right, what are we doing?
Well, the defense attorney got out of the case. We've got a new attorney in on behalf of the defendant. I think she wants to ask you for some additional time for discovery.
That's correct, Your Honor. I would like to
Counsel, go ahead.
ask, I'm sorry.
Go ahead. Go ahead.
I would like to ask that you open discovery on this matter. We're open to settling. We just need additional information to go ahead. For both of the matters, we would ask that you open discovery. 60 days, if that's okay with Mr. Betts.
Written discovery?
Yes, Your Honor.
That's
With
fine with
another
me, Judge.
pretrial? I'm sorry, Mr. Betts?
That's fine with me. 60 days written discovery.
And then another pretrial?
That's fine.
Yes, Your Honor.
Okay, does that take care of it?
That does it for me.
It does take care of those two cases, yes.
Okay,
Thank you, Judge.
you're welcome, Ms. Willingham. And Mr. Betts, does that leave you with Grossbeck versus Otto?
That's correct, Your Honor, but I don't see the opposing attorney on the.
He's in the waiting room and I'm bringing him in right now. He or she, I apologize. They're not connected though. It's Jamila Nabulas, I think it is. I'll send the chat. There we go.
Good morning. Appearances on Grossbeck RX versus Auto Club.
Morning, Your Honor. John Betts for plaintiff Grossbeck RX.
Jamila Nabulsi on behalf of Auto Club.
Good morning. Last time I had this file in front of me was mid-February. We adjourned for discovery, I believe. No, we adjourned to see what was going to happen in Third Circuit. So where are we at?
We made a phone call to plaintiff's counsel yesterday, and we were just waiting on a phone call back to hopefully settle this matter.
There is a settlement offer on the table. We're going to try to settle it. I'm not positive at this moment if it's going to get settled, but we're going to try hard to do so.
So what do you want to do? You want to put it on the trial docket, adjourn a pretrial date out? What do you want to do?
Is your court scheduling trials?
Bench trials.
I imagine this was a jury demand by the defendant.
I can check.
There was a jury demand made. I don't know if that jury demand still plays.
I would assume we would want to reserve that right.
All right. So how much more time do you want to explore your settlement? I'll set another pretrial.
Maybe 30 days, if that's okay with you.
30 days ought to do it, Judge.
Okay. Anything else?
No, Your Honor. Thank you.
Yeah, thank you.
Have a good day, counselors.
You too.
Judge, I do have Miss, it says Ashley Nonis for Burnt and Jennifer Jones. Both of them are in the waiting room. I don't have any others for for the Burnt cases. I'll bring
Repeat
them
that.
in.
You don't have what?
Carol Burns, Nonis, who is standing in for her, obviously, has 4 cases, but I only have 1 defendant. So I'm going to bring in that defendant and Ms.
Go ahead.
Nonis. And it's Jennifer Jones is the defendant. So the case is Jefferson Capital versus Jennifer Jones.
Good morning, Your Honor.
Good morning, counsel. Are you bringing Jones
Yeah,
in?
just taking her a few minutes to come on in.
While we have those couple minutes, Your Honor, I was kind of listening to your clerk. I do have another one that doesn't seem ready, but I also have one later today at 10:30, and I have 2 other ones with Judge Green. So I might be a little late to the 10:30 one.
Okay.
Actually, I have 2 at 10:30. Oh, then I may.
Credit acceptance and Arbor Knoll Apartments.
I think the credit acceptance one got dismissed, but I will look into that one.
Okay.
What was the defendant on that one? Credit acceptance?
Byers Wilson.
Thank you.
You're welcome. It looks like
Good morning, Ms. Jones.
she's not connected yet, Judge. I'm gonna send her a chat.
Ms. Jones, can you hear me?
I hear you now.
Good morning. Counsel, your appearance for Jefferson Capital.
Sure, Attorney Ashley Nonis, P77029 for plaintiff.
All right, Ms. Jones, today's the date and time set for a pretrial. A pretrial is an opportunity for me to get information about the file, so hopefully I can put it on the calendar and move it towards resolution.
Okay.
Counsel, where are we at from plaintiff standpoint?
Well, it just looks like the defendant took out a loan to pay for some health services. She did make payments on the loan, however, at some point stopped making payments, so there remains a balance due and owing. We haven't had an opportunity to chat. I think we attempted to try to call her and didn't get a response. So we're open to settlement or discovery or whatever she needs to do.
Okay. Ms. Jones, I can put you in a breakout room with counsel if you'd like to have some discussion this morning and see if maybe you can settle the case.
Okay.
All right. Paula, put the ladies in a breakout room. I'll bring in this iPad and figure out who they are.
Me very well, right? So what it taught me was I don't have to, I don't need to ask for help. I shouldn't ask for help, and then when these issues came up for sure.
iPad, what is your name?
Yes, Scott. Yes, yes.
Stephanie Small.
Say again. I'm getting a lot of background noise from wherever you're at.
Stephanie Small. I'm in my vehicle.
She's the other case for
Thank you.
misnonas.
Ms. Small, do you have your car radio on?
Actually, I'm in, hang on, let me see if I can put this. Okay, is that better?
It is better. Thank you. We're going to put you back in our waiting room. The attorney for Jefferson Capital is in a breakout room with somebody else, so we'll get you back out when we can put you in a room with her.
Okay, thank you.
You're welcome.
We have the attorney on Messina versus Masonry, but there is no defendant yet.
What's the file again?
Messina Concrete versus Masonry Unlimited.
Yeah, I'm having trouble finding that. And I don't see SC Lube on our docket anymore.
It's
At least
on,
I don't have a
it's on
file
at
for it.
8:45. It's the defendant, and it's a hearing for small claims. It's Elizabeth McFarland versus Lubestop.
Yeah, and the one you've got an attorney for, give it to me again.
Messina Concrete versus Masonry Unlimited.
I don't know why, but I can't understand a word you're saying.
I wonder, oh, Messina Concrete versus Masonry. I'll let Sandy know.
Who's William Reiner? Automobile Club?
I'm going to find out who Diane is, Judge. Yeah.
Listen.
We don't have the case because she said it's a 2018.
Okay. I still haven't figured out what it is. But you only have one side. Find out who this lady is, please.
Good morning.
Good morning.
Can you tell me what case you're here on, please?
Sure. I'm here for Jennifer Fallon. It is JP Morgan Chase versus Michael Luciani. Case number 210418.
Okay, and you're scheduled at 9 o'clock?
Yes.
And I'm sorry, you're here for Jennifer, for Michael Luciani?
Yes.
Okay. We don't have that defense or the plaintiff's attorney checked in yet. So I'm just going to put you back in the waiting room. And as soon as we get in, we'll let you know, okay?
That's fine. Thank you.
Thank you.
Good morning, counsel. You calling in on Messina?
Yes, Your Honor.
All right, let's give him a few more minutes, see if he's going to show up or not.
Okay,
We'll put you back in the waiting room. We'll keep an eye on the time.
very good.
I see another attorney, Judge, but I want to find out who he's here on. I don't recognize that name. Good morning, sir. Can you tell me what case you're here on, please?
Yes, I'm here on Capital One Bank versus Caitlin Hootson.
What time was that scheduled, please?
9 a.m.
You have the case number?
I do. 210025 GC.
Okay, here it is. And you're here for?
Capital One Bank.
We have a Caitlin Butson. Is that the same person?
That's what I said.
I thought you said Beck.
No, Butson. Butzin.
Okay.
I must have broke up.
And you're Mr. Kirschenheider?
Yes, ma'am.
Thank you. Okay, we don't have that plaintiff's attorney in yet, so I'm going to put you back in the waiting room, okay?
Sure. I'm the plaintiff's attorney, though. We're waiting for a defendant.
All right, thank you.
Yep, no problem.
I'm really sorry. I thought you said you were appearing for Caitlin.
No,
Hang
I'm
on.
appearing for Capital One Bank. No worries.
All right, hang on. I'm going to put that on you so that we know when we bring you back in.
Sounds good. Thanks.
Good morning, Mr. Renner. Which file are you on?
I'm here on behalf of Automobile Club of Michigan.
Versus Graham.
Yes, that is correct, Your Honor.
Okay. I do not see defense attorney in the waiting room, so we'll put you back in the waiting room until we find him.
Fine. Thank you, Your Honor.
You're welcome.
Okay, it looks like we've got everybody identified.
I think so.
And it looks like Ms. Nonis and Jennifer Jones are coming back in now.
Hello.
Okay, ladies, you're out of the breakout room. Did you have enough time?
Well, yeah, we were in the middle of a sentence, but we're good. We did resolve it.
Okay. Where we at?
So we have reached an agreement that the defendant's gonna resolve it by paying a lump sum of $1,000 by this Friday. I explained to her how to make the payment to call in, and I was in the middle of explaining to her, the stipulation to dismiss and maybe setting a control date. So just to finish that thought, if she can hear me, we'll set a control date just in case something doesn't happen according to plan, but as long as it does, then we won't have to appear to that hearing.
Okay.
Counsel, what I'm going to suggest is I'll put it on my no progress docket for no sooner than 30 days out.
Okay.
So if we don't hear from you, then we're just going to dismiss the case.
Okay.
All right, Ms. Jones, any questions?
I do have a question. This won't be put on my credit report, will it?
It may already be. Us as a law firm, we don't credit report. So creditor does that. If it is, all you have to do is submit your dismissal to them, to the credit bureau, and it should be okay. I can also make a request that they remove it once it's been paid, but that could take up to 30 days. So it might be better if you kind of take care of it through yourself.
Okay.
Anything else, Ms. Jones?
No, that's it.
You're all set. Good luck.
Thank
Have a
you.
nice day, Jones.
Counsel, we've got Stephanie Small coming in.
Okay.
Your appearance for the record.
Good morning again, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
Have you had a chance to discuss with Ms. Small possible settlement, or would you like a breakout with Ms. Small?
Well, we'll do both to kind of update the court. The defendant filed an answer contesting. We sent a fraud packet back in March and never received a response to that. So
Okay.
I'm not sure we're going to reach a resolution, but maybe we can kind of chat real quick and see what's going
Okay.
on.
Ms. Small, you understand that? We're going to put you in a private breakout room with counsel. Ms. Small,
Yes.
understood?
Yes.
Okay, we'll put you in a breakout room. Paula, we got somebody named Sparks on the docket.
I was just checking it out to see if I could figure out who he was before I brought him in. Are you able to hear me a little better now?
Seems to be. Good morning, Mr. Sparks. Who are you here for?
Morning, I'm here for JP Morgan Chase versus Luciani.
Who do you represent?
JP Morgan Chase.
Miss Zagoras is the other attorney on that.
Yep, bringing her in. All right, JP Morgan Chase versus Michael Luciani. Appearances.
Good morning, Keith Sparks here on behalf of the plaintiff, P77485.
Good morning, Diana Xagoraris appearing for Jennifer Pellon on behalf of the defendant, Michael Luciani, P32106.
Thank you. And today's the date and time set for pretrial. So what do you folks need from the court?
We would just request 60 days discovery. I see that we've had some conversations regarding settlement, and it doesn't look like they're too far apart. But it looks like the last conversation was about 2 weeks ago. So hopefully we can get it wrapped up here in the next little bit.
All right, we talking about written discovery only?
Yes, please.
For defendant, yes, written's fine.
All right, in 60 days, we agree?
Yes.
Yes.
All right, we'll just schedule another pretrial. How's that?
Sounds great. Thank you very much, Your Honor.
Thank you.
All right.
Mr. Sparks,
You're welcome. Stay safe.
Are you going to handle all of Mr. Nate's cases?
Well, we're from the same office. Did we have other hearings for right now?
There's one at 9:15. Hang on just a second. Let me.
What was the file for 9:15? Because I see one.
That's the only other one he has. It's 9:15.
Who's the defendant on that one? Sorry.
Midland Credit versus Annette Dumas.
DUMAS.
Yes, sir.
And then what was the first name?
Annette.
Oh, Annette. Okay. Let's see here.
I don't see her in the waiting room, but
Yeah, we don't have that. That is, let's see here, 203467 GC.
yes.
We didn't receive the notice here, but
6-7.
obviously. Sorry.
Go ahead. Go ahead.
Oh, we didn't receive the notice of hearing, but obviously, yes, I'll stick around and cover that and wait to see if she appears.
Okay, I'll put you back in the waiting room, okay?
Thank you.
Thank you.
Ms. Muriel, what file are you here for?
203480,
How about a name?
Sharina Morrell, for Ford
No,
Motor
what's the-
Company.
Ford Motor. Thank you. Thank you. All right. I don't see the attorney for plaintiff yet, so we're going to put you in the waiting room until we get them here.
Okay.
Thank you.
Looks like we've got Mike Levitt in, but I don't see any of his.
No.
Oh, he's only got two, and it's the same defense attorney on both.
Are they both same plaintiff?
Yes. Just one case number off.
Yeah, I'm having trouble finding the other file then. No, I got it. Good morning, Mr. Levitt.
Good morning, Judge.
We do not have the other attorney for Metro Direct.
Okay,
Just want to let you know we see you. We know what cases you're on and we're ready for you.
I appreciate it. How things going?
I hate this stuff.
Yeah. Yeah,
It was old a year ago and it's not any better now.
yeah, I understand that. So,
We did move into our new building though, so that's a good thing.
no, I can't wait to go in and see it.
Unfortunately, I can't use my courtroom because the HVAC noise is so loud I can't do business.
Oh,
So we're trying to figure that out.
well, you got to get on Al on that. So you're gonna have to dock him a paycheck.
Well, if it was a technological issue, it'd be in his wheelhouse, but HVAC was not his wheelhouse.
How's the new bowling alley in that place? Is it working out? In the basement?
We didn't put a basement in.
Oh, okay. You put on a slab, eh? Huh.
Yeah. All right, I'm gonna put you in the waiting room till we see what we can do.
All right, thank you.
And they're coming back in right now from the
Yeah.
breakout room.
Your Honor, we were almost there. Can we just have a couple more minutes?
Yeah. We got lots of time for
Thank
you.
you.
We'll put you back in the waiting room,
Thanks.
or the breakout room, excuse me.
Thank you. Thank you.
Good luck. Hey, Paula, I do not have a phone in here, so could you call and see if Civil has heard anything from the small claims plaintiff McFarland that was scheduled at 8:45?
I'll do that right now, Judge.
I have not heard anything, Judge.
All right.
Thank you, Sandy.
Paula, do you see the name
You're
Deborah
welcome.
Winslow on that docket?
Yes, it just popped on.
No, that's the waiting room. Is she on the docket was the question.
Oh, Winslow, I'm sorry. Anticipating him. I do not. You want me to bring her and find out who she is?
Just did.
Okay.
Good morning, Miss Winslow. What case are you on?
Good morning, Your Honor. Deborah Winslow on behalf of Ford Motor Credit versus Murrell.
And we have her in the waiting room.
Okay.
I'll bring her in.
All right, counsel, one more time. You're appearing for Ford Motor, please.
Good morning, Your Honor. Deborah Winslow, P63179 on behalf of the plaintiff Ford Motor Credit Company.
Thank you. Miss Morrell, you can hear us okay?
Yes.
All right. So this is a pretrial. We've last met mid-March and adjourned for discovery. So from the plaintiff standpoint, where are we at?
Your Honor, I don't know if it's reached the court yet, but we did file a motion for summary disposition that I believe is noticed up for June 19th, I believe.
Okay. It doesn't look like it made it in yet.
Okay, it's on the way.
Okay.
I think it went out
Okay.
maybe on Friday.
All right.
So that's
Miss-
kind of
is
where
it
we're
Mural
at.
or Murrell?
Morel.
Morrell. Miss Morrell, let me try to explain that. First of all, motion is just a fancy legal word that we use instead of saying request. So Ford Motor Company has filed a request to us basically saying that based on the law that applies to the facts in this case, they are entitled to a judgment against you. You'll get a copy of that document. You can respond to that document in writing. You'll have a chance to respond to that document orally on the court date, which according to counsel's memory is June 19th, Ms. Winslow?
Yes, I can look that up real quick too. I'm
Okay.
sorry.
You'll get a notice of that, Ms. Murrell. If I buy their argument, if I agree with their argument that there is no material factual dispute, in other words, no important facts are in dispute, I'm going to give them a judgment. In essence, other than collections, the case would be over at that point. If I do not agree with their argument, then I'm going to deny their motion, deny the request, and we'll set the case for a trial. Do you understand procedurally where we're at?
Yes. The only issue is July and June 19th. I am, as of now, scheduled to be out of town with my son for his football tournament.
I did just look it up.
college.
It's June 22nd at 9:15.
Yeah,
I
we're,
apologize.
I can, because we're supposed to be gone from the 19th, well, from the 15th through the 21st. So the 22nd, I should be back.
Okay.
As
Okay,
far
if
as
your
I know
plans
of.
change, just let us know ahead of time, especially with Zoom. It's not that big a deal to find some time where we can reschedule that.
Okay.
Thank you, Your Honor. Thank you,
Right?
Ms. Murrell.
So
Yes.
what you're doing now is you're looking for some paperwork. And it sounds like it's probably in the mail. So you'll be getting something from the plaintiff's office. It'll be a copy of their motion or their written request with a notice in there about the court date. Understood?
Okay. Yes, I didn't receive anything the first time this was supposed to happen either, or is that known already?
What do you mean the first time?
Well, when
You mean last time we were in court, we talked about a
Yes.
motion?
Yes.
Yeah, it just got filed. It didn't get filed before then. So counsel, and actually, I don't even think it's filed yet because I don't have a note.
Right. It looks
in the
like the
file.
proof of service,
So it's
it went out
probably in
on
the process.
Friday, the 14th.
Yeah, so we haven't processed this here at the court yet.
Okay.
So I would suggest, Ms. Morel, if you don't have anything in a week or so, then it might be time to get a little bit nervous.
Okay.
And Ms.
Okay.
Murrell too, if you want to ever call our office, we can talk about it. And if, there's any possibility of working something out, we're happy to talk about that as well.
Okay.
And what was the date again? 22nd?
Yes, June 22nd at 9:15.
Okay. All right, Ms. Morel, good luck to your son and his team.
All right. Thank you.
Thank you, Your Honor.
All right.
Thank you, Ms. Murrell. Bye-bye.
You're welcome, Ms. Winslow. Okay. Jefferson versus Small. You got enough time, ladies?
Yes, we're ready.
Yes.
All right. Tell me where we're at.
So, Your Honor, we did resolve the matter by a consent judgment, whereas the defendant's going to pay $50 per month on the full balance, including costs, which would total $51.25 and 23 cents. Her and I are going to have a 6-month review to see if we can increase payments. We won't bog the court down. We'll just touch base, see where she's at. The first payment is going to be June 7th and then the 7th thereafter. So I'm going to send her the paperwork and how to make payment, all that kind of stuff. And just to let the court know, she did also update her address. So Ms. Small, do you want to provide the court with your new address?
Yes. My address is 29095 Franklin Hills Drive, apartment 205, Southfield, Michigan, 48034.
Thank you,
Apartment number
Ms.
was
Small. I
205?
kind of cut you off for a second, but just to let you know, my full name is Ashley Nonis. So when you call the office, if you need to talk to me, just ask for me and they'll transfer you over, okay? I know you were asking me before we kind of got out of the breakout room.
Okay.
Ms.
And that'll
Small,
be on the
apartment number was
paperwork for you.
205?
Yes, sir.
Thank you.
Yes.
All right, so how much time do you think you ladies need to exchange paperwork and get it to the court?
I'll send it out today, Your Honor. So if you want to do like the last case, just put it on the no progress for 30 days. We should be fine.
Perfect. All right, any question, Ms. Small?
No,
Ms.
sir.
Small, any
I'm
questions?
not sure what's. No, sir.
Good luck. Have a nice day.
Thank you. See you later, Your Honor.
Stay safe, counsel.
Judge, the plaintiff on the small claims, Elizabeth McFarland, was in the waiting room and she dropped out. So
All right, do you know who Danny Horan?
Danny
or
Horan
Faree's
is the,
partner?
yes, Danny Horn is the attorney on Mid Apartments versus Ruby Markham. He's defense attorney with Carrie Side.
All right, so we don't have the other side on that one. Do you know who
Not yet.
Parton is?
No, I'm going to bring her in and find out.
Counsel on Messina, your appearance.
Morning, Your Honor. For the record, Roy Scruggs appearing on behalf of the plaintiff.
All right, I have not got anybody in my waiting room that we don't know who they are. Well, other than a Faree's Parton. Does the name Faree's Parton ring any bells with Masonry Unlimited?
No, no, that would be Eric Benedict.
All right, so what's your pleasure?
Well, I'd request the court issue a bench warrant.
What's your judgment amount?
$24,268.31. Now, so
And
the
what's
court's aware
Benedict's
we have-
position with, I'm sorry?
We have collected roughly 17,000.
All right, so you've got a balance of seven-ish?
Yeah, 8,000 and change.
Okay, and what's Benedict's position with the LLC?
He's the owner, sole member.
Okay, okay. All right, I'm gonna make a note in the file, bench warrant to issue $3,000. If you prepare the paperwork and get it into the clerks, we'll sign it and make it real.
Will do. Thank you, Judge.
All right, have a
Have a
great
good
day.
Ms. Parton, can you unmute yourself, please?
Yes, sorry.
Thank you. Can you tell me what case you're here on?
Actually, I have Midland Funding and Crown Asset Management. At
I'm sorry, I
9:30.
can't hear you.
Sorry. I have Midland Funding and Crown Asset Management at 9:30.
You're standing in for Elizabeth Smith?
No, I'm defendant.
Oh, I see. I'm sorry.
All right,
Yeah, we don't have that.
yeah, I got you. Okay, I got the files. So we're looking for Elizabeth Smith and David Kanan. All right, Ms. Parton, we know you're here. When the other side gets in, we'll get you back in the meeting and we'll hopefully take care of some business.
Okay, thank you.
What do you want to do? Elizabeth McFarland did come in, but then she dropped out after just a few seconds.
Mr. Stemrich, can you hear me?
Yes, sir. Sorry, I was just trying to figure out how to change my name, but apparently it's in there. So, good morning.
Good morning. Did I say it right, Stemrich?
Yes, sir.
Okay. Ms. McFarland was in our waiting room briefly. What was that, Paula? Probably 5 minutes ago, 4 minutes ago?
Yeah.
But she was just there for a minute and then she disappeared again. So I'd like to give her a few more minutes and see if she's going to show up. I don't know if she's having technical issues or what the problem is.
Okay.
But I know you've been there for quite a while. I just wanted to touch base with you and let you know what was going on.
Yes, sir. Thank you.
So we'll put you back in the waiting room.
Okay, thanks.
Paula, you want to bring Carrie and Danny Horn in?
Good morning, Judge.
Morning, Judge.
Good morning. Mid Apartments LLC versus Ruby Markham. Appearances.
Carrie Side, P67390 on behalf of the plaintiff.
Danny Horn, P81774 on behalf of the defendant.
Good morning, people. Where are we at with this file?
Your Honor, both parties have applied for the Sarah funding. And I know that Danny tried to look yesterday on the website he couldn't get on, but the applications have been submitted, so we're just waiting at this point.
Okay, here's what we've been doing with these is we've just been putting these, basically putting the files on ice, entering a stay.
Okay.
And Carrie, I'm not sure exactly. Sandy will correct me if I misspeak, but I think the notice that goes to the plaintiff is if we don't hear from you within 45 days, then it just gets dismissed.
Okay,
It just
and that's-
seems to be a cleaner way for us to do it. So we're just not constantly having files on our adjournment docket.
That works, Judge. Clinton
Mr.
Township's
Horn,
doing almost the
understood?
same thing.
Yes, understood.
I'm
Sorry,
sorry?
I don't know what Carrie, Ms. Side was saying there just now.
I just said that Clinton Township's doing the same thing.
Okay.
Yeah, we just started it maybe 3-4 weeks ago. It seems to be working.
So just to,
Okay,
this is
anything
my
else we
first
can
time.
accomplish?
Well, I'm sorry, Your Honor, this is just my first time hearing about this process. So just so I'm clear that we'll put in a stay and that if
Yeah,
45
basically
days.
you just sit back. Yeah, you just sit back and wait and see what happens.
Okay.
We're doing it with the understanding that the Sarah is going to kick in and then everybody's happy. And if not, it's on plaintiff to
on me.
trigger something with the court. Yeah.
Understood. No, I appreciate the clarity. Thanks for that.
Okay.
And
You're welcome.
Carrie as well.
You're welcome. All right. Have a good day, people.
Have a good
Thanks,
day.
you as well.
Thank
Bye
you.
now.
Go out and make some real money.
I'm going to bring in Franklin Carpenter. I have no idea what he's here on.
Sure.
And I just chatted with him to bring himself in audio.
Can't hear you.
Sorry, I don't see him on the docket anywhere.
Yeah. Would you call the attorney for Metro Direct?
Yes, sir.
I got a number if you need it. 734-955-7277. The attorney's name doesn't have a number under it. The attorney is Larry Dressel, Dressell.
Actually, I can look the attorney's number up in JIS.
Good morning again, Mr. Renner. Your appearance for Automobile Club of Michigan.
Your Honor, William Renner, P29832.
Counsel, this matter was scheduled at 8:45 for a pretrial. It's now 9:26. Here.
Yes, Your Honor.
What's your pleasure, Mr. Renner?
Whatever the court's normal practice is, Your Honor, I've been an attorney as of Friday, 42 years. I've never made it a practice of burning another attorney because he failed to show up, but it's what the court wants to do is fine with me.
Have you had any contact since March 16th?
I am unaware. The notes from the filing don't indicate anything other than filing the answers to the interrogatories.
Why don't you submit it under the 7-day rule? That gives council plenty of time to put a Band-Aid on it.
That's fine, Your Honor. I will do that.
All right, council. Thank you. Enjoy your day.
Thank you, Your Honor.
Mr. Carpenter, what case are you calling in on?
I'm sorry, I don't know.
All right.
It's
I'm sorry, who's this?
Franklin Carpenter.
Yvette, this is Paula from Judge Oakley's
You don't know
office.
what
We're
case you're on?
expecting Your attorney, Larry Dressel, to.
Paula,
call
mute
in on
yourself. Mr. Carpenter, you don't know what case you're on?
Yeah, I don't know the case number, but
Case name. Who's the parties?
Ready Dig and Harvey Communication.
Ready Dig and Harvey Communication?
Yeah.
I think maybe you're in the wrong Zoom room. What time was it scheduled, sir?
9:30.
All right. Have you had contact with your attorney, Mr. Rucker?
Yes.
All right.
Mr. Rucker is in the waiting
Well,
room.
looks like you're the first one of the parties.
Mr.
Bring
Rucker
him in.
is in the waiting room.
Bring him in.
He's on his way, Judge.
All right. Attorneys, appearances for Carpenter versus Miller and Harvey Electronics.
Good morning, Your
David
Honor.
Sebastian. I'm sorry, go ahead, Mr. Rucker.
Good morning, Your Honor. Tyrone Ruck on behalf of Mr. Franklin Carpenter, also known as Ready Dig Excavation, P number 61867.
David Sebastian on behalf of the defendants, P47139.
All right. So what do we got today, gentlemen?
Your Honor, this is a hearing on a default judgment that was entered on behalf of the defendant. Opposing counsel then filed a motion to set aside the default, which was granted. I then objected because I did not get proper notice of the hearing regarding the default judgment hearing. And basically, essentially, we went through all the steps. The client was served, or opposing client, the defendant in this action was personally served by a court officer and failed to do anything. Was personally served from a court officer from this point, and waited and did nothing until we actually had a judgment. And then they wanted to default. I don't see where they've showed or filed an affidavit showing where there's a meritorious defense with regard to this. We're perfectly capable of going to trial, but based on the merits of this case, but I don't see where he has a meritorious defense.
I think your audio froze, Mr. Sebastian.
Okay. We have a little different take in terms of where we're at today. We were here 2 months ago on this motion, and the defendants did not appear. And so the motion was granted. We submitted an order for entry, and the plaintiffs objected to that, saying, well, they didn't get notice of the hearing. So it's a little ironic that they're claiming a lack of notice as a basis to proceed with a default judgment where my client as defendants never received notice. And it's an improper objection to the order as far as that goes, because we already had the hearing. The order was granted, the defendants didn't appear, and the case should proceed. But as the notice to appear came, it said that we're gonna re-argue this motion. Now, as for the basis of the motion, a complaint was filed back in October for $5,500. On November 1st, it was amended to seek $7,900, approximately 50% more. My client doesn't have the complaint or the amended complaint. The Register of Actions does not indicate that the amended complaint was ever filed or was ever served, excuse me. And then a default judgment was eventually filed a few months later. A hearing was held on the default judgment. Now, once the default was entered, the court sends out notice to the defendants of the default judgment hearing. So that wasn't done by the plaintiff. It's not necessary to. The court does that. But the address that was used for the defendants was an incorrect address. So the defendants were not at that address. They have never had notice of the hearing. That's why they didn't appear. There's case law, as we set forth in the motion in the brief, which is Bradley versus Fulgham, where the defendants don't have notice of a default judgment. That alone is a basis to set aside the judgment. So the judgment proceeded to get entered. The defendants never had any knowledge or notice of it. And it wasn't until a seizure order came earlier this year that we had to figure out, okay, what's happened with this case. And we still don't have the complaint, and we still don't have the amended complaint. And we asked for that too, from the plaintiffs multiple times, including in the proposed order, and we still were never provided with the complaint or amended complaint. So all we're asking the court to do is set aside the judgment in the order for seizure and let the case proceed on the merits. And there's a lot of case law that suggests the appropriate thing to do, and as well as, the various court rules, the motion to set aside the default judgment that opposing counsel admission isn't really applicable because this case, the judgment's 2.5 years old now. So we have to rely on the other court rules, the 2.612, and the other case law that says when you don't have notice of the judgment, that alone is a basis to set it aside.
Your Honor, if I may, first, Court Officer Robert Bandley personally served him. The proof of service was submitted to the court. It was done on November 12, 2019 at 10:10. He both served him personally, Benjamin J. Miller, as well as the DBA as well. And he served him at 28287 Beck Road, D2. I mean, it's in the record. As with respect to, I've never had a request for any complaints or anything, I would have gladly done that. I mean, we weren't hiding anything. We were looking forward to our day in court. He didn't answer the complaint. He was personally served. I don't know what to say. And then certainly we would have come to court had we been given proper notice. We've gone through all this, and then just to ignore a hearing or default, that wouldn't make any sense. And so that's why we said, well, let's have a hearing. And if the court decides, well, okay, they want to give a trial, we can set a trial date right now. But he was served, and he was personally served. I don't know what to say. He was served. Is he now saying he doesn't believe the court officer?
There's no proof of service as to the First Amendment complaint in the Register of Actions.
All right, there's no proof of service on the amended complaint. What about the original complaint?
I don't have that, and so I'm not sure again, I don't have any other pleadings in this case. So I'm not sure what the plaintiff's referring to. I've just had to go through the Register of Actions.
I'm referring to the proof of service where it says where the court officer wrote out together with amended summons. Everything is in order.
So,
I can email
I don't know why the
to
summons would be amended either. I mean, that just doesn't make any sense.
Well, you would have to ask the court officer. I can just tell you what he wrote down.
But if what I heard my opposing counsel argue that he's ready to go to trial, I mean, that's fine. We can have a trial. We'd like to see the complaint first and answer it and raise the appropriate defenses to it.
Well,
I don't
your
know how the
client was
amount went
served.
from 5,500 to 7,900 either.
Your client was served.
In
All
the
right, so
address
I'm
of the
not going to
court.
set aside the default judgment. Gentlemen, I'm not going to sign the order setting aside the default judgment. If you want to have a full-blown hearing on that motion to set aside a default judgment, I'm more than willing to do that.
So yes, we'd like
Understood?
to have what do you mean by a full-blown hearing? An evidentiary hearing or?
Well, a hearing where both parties can speak, because Mr. Rucker didn't have that chance the last time this was scheduled.
Okay, I mean, well, he just had that opportunity now, but I'd be happy to have another hearing if the court wants to have another one.
Okay. Motion to satisfy default judgment is denied. I see good service. I haven't seen a meritorious defense. Anything else, gentlemen?
No, Your Honor.
Are we going to schedule another hearing?
No, you just said we had our hearing, so I just gave you a ruling. Your motion is denied. Anything else?
Thank you very much, Your Honor.
Thank you.
Thank you, gentlemen.
Thank you.
Judge, we now have Elizabeth McFarland in for the small claims with Loop Shop. We also have Mr. Dressel in for Mike Levitt.
All right,
Pardon?
bring Dressel and Levitt in, please.
All right, thank you.
Bring the attorneys in on interstate.
Good morning.
Good morning, gentlemen. I've got two files, interstate. Mr. Dressel is muted. I'm not hearing anybody.
Can you hear me, Judge? Mike Levitt here.
All right,
Now I can. Appearances, please.
Larry Dressel here on behalf of the defendants.
Michael Levitt, I appear on behalf of the plaintiff.
We've not had an opportunity to.
All right, gentlemen, pretrial scheduled on these files, I believe.
Yes, Your Honor.
If maybe we could have a chance to talk in the side room, we might be able to settle it, Your Honor.
That would be fine, Judge. So,
All right, Paul, we'll make that happen.
Okay, thanks.
thank you.
Hang on, Mike.
Okay, do you want me to bring in Mr. Stemrich? Oh, okay,
No, that's going to take too long. We're going to make
Thank
them wait
you.
a bit.
okay. Judge, you just keep, you're like cutting in and out.
I don't know what to do about it.
I'm sorry, who did you want me to bring in? Ms. Parton?
I'm trying to bring her in.
We also have a Darnisha Pickens that Mr. Canine is the attorney for the plaintiff on. It looks like she came
Who's the
in
plaintiff?
twice.
The question was, who's his plaintiff on that file?
Sorry, Crown Asset.
I tried to admit Miss Parton, but
I think she came in.
for some reason, she's
She
not
came
coming
in
in.
twice, so I'm bringing her in on the second one. There we go.
Miss Parton, can you hear me?
Yes, can.
Counsel, your appearance for Crown Asset Management.
Good morning, Your Honor. David Canine, last name spelled Canine, P61828 on behalf of the plaintiff. Thank you.
All right, in April, we adjourned this so you could have discussion. Where are we at?
We answered some discovery, Your Honor. I don't believe we're going to be able to resolve this. I'd like to file a dispositive motion now, please.
Okay. All right, Ms. Parton, plaintiff's going to file a motion for summary disposition. What that is a request to the court asking for a judgment. Basically, what they're going to, the argument they're going to make, counsel, correct me if I'm wrong, but the argument they're going to make is that there are no factual disputes based on the facts, based on the law that applies to those facts. They're entitled to their judgment. You'll see that on paper. You'll have a chance to respond to that in writing. You'll also have a notice and a hearing date where you can respond orally. So in other words, we'll get together at some future date after you and myself have both seen the paperwork filed from Crown Asset. You understand that?
Yes.
If I agree with their argument, then I'm going to enter a judgment against you. If I disagree with their argument, then we're going to set the case for trial. Mr. Canine, you agree with my explanation?
Yes, I do, Your Honor. Thank you.
Ms. Parton, any questions at this point?
No.
All right, so you're going to be looking for some paperwork then.
Judge,
You're all set, Ms. Parton. Good luck.
Judge Sandy was going to ask you something.
I was just going to say I could give him a date of July 20th at 8:30.
Counsel at work?
That'd be fantastic. July 20th at 8:30.
Yep. Thank you.
Thank you.
Do you want me to bring in Miss Pickens?
I just clicked her.
Okay, thank you.
Good morning, Ms. Pickens. Can you hear me?
Yes, can you hear me?
I can, thank you. Counsel, your appearance for Crown Asset Management.
Again, David Canine, last name spelled Canine, P61828 on behalf of the plaintiff.
All right. Ms. Pickens, today's the date and time set for a pretrial. A pretrial is an opportunity for me to get some information about the file. So hopefully we can put it on the calendar and move it towards a resolution.
Okay.
Counsel, would you like a breakout room with Ms. Pickens?
Please, thank you.
All right, Ms. Pickens, we're going to put you in a private chat room with counsel.
Okay.
Gentlemen, on interstate, did you have enough time to talk?
We're getting close to a settlement. We'd ask that maybe we can reschedule the pretrial. And then he'll get a chance to talk to his client and mine, and we'll maybe perhaps get it settled.
Sure. How much time you need?
What, about a month, Mike?
Yeah, that'd be great, Larry.
Sorry, I didn't get
All
here.
right, it'll be at least 30 days. You'll get a notice.
All right.
Thank you.
Thank you. Good job, Brian.
Have a good day, gentlemen.
All right.
All right.
See you, Mike.
All right, see you, Judge. See you, Larry.
I'm going to try to identify a couple of these people, Judge.
Sure.
Galaxy Tab A, can you tell me what your name is, please? Ma'am, can you tell me what your name is?
Hello,
Hello, can you tell me
Hi.
what you, can
I'm
you tell
sorry.
me? That's okay.
Sharice
you-
McDaniel.
Sharice McDaniel?
Yes, ma'am.
And what case are you on?
Case number 210402,
What time are you scheduled?
10 o'clock.
Oh, I see. Okay. Okay. We do have the other party. We are going to put you back in the waiting room for just a few minutes.
Thank you.
Okay?
Mhm.
You're welcome.
Counsel for Capital One, your appearance.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
Wonderful. Counsel, this was scheduled at 9 o'clock. It's now, according to my clock, 9:48. I do not see Ms. Butson in the waiting room. This is a motion for summary disposition.
That's correct, Your Honor.
You win.
Thanks, Judge. I could file an order.
Please do.
Will do. Thanks, Judge. Have a great day.
Have a great day yourself.
We have Misty Russell and Brian Gerda from Garner Property, Judge. And that's at 9:45. Okay.
Okay.
And we also have Mr. Canine and Ms. Pickens back from the breakout room.
All right, Mr. Canine, where are we at with Ms. Pickens' file?
Your Honor, parties had an opportunity to speak. We're actually very close to resolution. She's using a debt management company who's supposed to contact our office in the next day or
Okay.
so. If we could have maybe a 30-day adjournment, I don't think you'll probably hear from parties again. Thank you.
If you're that confident, why don't I just put it on our no progress docket? That way we just dismiss it if we don't hear anything.
That's fine. That's okay with me. Thank you.
All right. Ms. Pickens, you understand that?
Yes, Your Honor.
Good luck to you.
Thank you, sir.
Thank you, Your Honor. Thank you, Ms. Pickens. Take care. Bye-bye.
You're welcome. All right, looks like we're waiting for counsel for Garner to connect.
There's a couple of people, I'm not sure who they are. I'll check for them real quick.
Go ahead.
Oh, I brought in the wrong one. I'm going to put her back in. Sorry. There we go.
Ms. Russell, we're waiting for the attorney for Garner to get connected.
Sounds good. Thank you.
Good morning, Donna Michelle.
Yes.
You're welcome.
Can you tell me what case you're here on, please?
Pardon me?
Can you tell me what case that you are here on, please?
MEA with Mr. Cox. Can you hear me?
Yes. What time were
I'm
you
gonna bring
scheduled?
Mr. Yeah, you're fine, ma'am.
Okay.
Keith Cox. Yeah, he.
I got it, Paula.
Thank you, sir.
Good morning, Mr. Cox. Your appearance for MEA versus Ms. Donna Brown.
May it please the court, Keith Cox of Ingber and Winters on behalf of the plaintiff, P59146.
All right, last time we spoke, it's been a while, but last time we spoke, we talked about a motion being filed, and I believe today's the day.
Judge, parties have
It's
reached
been
a
adjourned,
settlement.
correct? Wonderful.
Yeah.
Tell me
Judge,
about it.
I spoke to Ms. Brown prior to the hearing. I spoke to her just before these proceedings. Judge, it's going to be a settlement agreement. We're going to conditionally dismiss the case. The defendant's going to pay a total of $1,597, which is 50% of the principal plus plaintiff's court costs. She's going to pay that at $100 per month, with the first payment due June 20th, similar payments on the 20th of each month till that amount's paid in full. The settlement agreement also will have a stipulation to reinstate in the event of default, and then a judgment for the full balance if she doesn't make the payments as agreed, minus any payment she's made to date. The settlement agreement will also afford her a 7-day grace period on all payments. And I'm going to email that to her. She gave me her email address. I'm going to email it to her later this morning. I would anticipate the executed documents will be submitted to this court probably within 7 to 10 days.
All right. So what I'm going to do is we're going to put it on our no progress docket at least 30 days down the road. So if we don't get anything from you, it's just going to get dismissed.
Okay.
Ms. Brown, you understand that?
Yes, sir.
All right. Good luck to you, ma'am.
Thank you very much.
Look for those documents.
Have a
ma'am. I
good day,
appreciate it.
folks.
Thank you, Your Honor.
Judge, I'm trying to call Mr. Gerta's office right now to let him know we need him to answer.
Thank you.
Hello.
Ms. Petway, can you hear me?
I can, Judge. How are you today?
Wonderful. Good morning. Which file are you on?
I am here on behalf of Midland. The defendant is Faris Parton.
And she's in the waiting room. I'm going to bring her right in.
Okay, thanks.
All right, Ms.
Yes,
Parton, are
sir.
you there? All right, counsel, your appearance for Midland.
Yes, good morning, Your Honor. For the record, Stephanie Petway appearing on behalf of the plaintiff.
All right, looks like we last spoke in April. I think we adjourned till today for discovery, correct, counsel?
That is correct, Your Honor.
All right, where are we at?
So both parties have exchanged discovery requests and responses. At this time, we still have not been able to reach a resolution. I anticipate my client filing a motion for summary in this matter.
All right, Ms. Parton, you understand how that works?
I do, but I also have not received any response to my interrogatories.
So you're still waiting for discovery requests?
Yes, sir.
Those were completed and sent. I don't have the date in front of me, but I can check that after the hearing. And I can give you a call or shoot you an email to update you, Ms. Parton.
Okay.
Ms. Parton, you mind sharing your email with counsel? That way she can probably email the discovery right to you.
Yes.
Okay. I'm ready.
F as in Frank, ARCEPARTON@gmail.com.
Let me just confirm. FARC like cat, EPARTON @gmail.
Yes.
Okay, got it. Thank you.
All right, anything else, ladies?
I think that's it, Your Honor.
Ms. Parton?
That's all. Do we have to wait on another date or?
Stay safe.
Thank you.
Yeah, you're gonna get some paperwork. You're gonna get some paperwork, and that will include a notice for when that motion is gonna be heard.
Judge, we can do that again, because she already has one set for 7:20 at 8:30. We can do that one with the other one.
Ladies, July 20, 8:30?
Yes.
Okay.
Thank you.
Thank you.
All right, have a good day, ladies.
You as well. Thanks, Judge.
You're welcome, counsel. All right, Garner Properties versus Russell. Counsel, your appearance.
Good morning, Your Honor. Brian Gerda on behalf of the plaintiff.
And Ms. Russell, you can hear me?
I can.
All right. So this is a date and time set for defendant's motion to set aside a default judgment, I believe, correct?
Correct.
Correct. And we're going to stipulate to that.
Okay, that makes my job a little easier today.
We'll We'll stipulate to
Counsel, you
set
want to-
aside judgment.
Go ahead.
We'll stipulate to set aside the judgment and then dismiss the case.
You
with
want
prejudice.
to? Oh, okay, that's even better, isn't it, Ms. Russell?
Absolutely. Thank you.
And Mr.
I didn't
Mr.
catch
Gerda,
that, Your
when are you
Honor.
gonna dismiss it? Yeah, I'm having trouble with
Sorry,
my
you broke
audio.
up
When
there a
will you
little
send
bit.
in the dismissal?
Today, I'll send one over.
When will you?
I'll do
send
an
in the
order
dismissal?
setting aside and then dismiss it. Today.
Great. All right, Ms. Russell, any questions?
Nope.
Thank you.
All right, thank you.
Judge, I think Mr. Sparks was standing in for Preston Nate, and he had one more at 9:15. Annette Dumas did not check in.
Let's find out. Mr. Sparks, you're on Midland Credit versus Dumas.
That's correct, Your Honor.
All right, that was scheduled at 9:15. It's now almost 10 o'clock, 9:58 by my watch. We did not see Ms. Dumas in the waiting room.
The parties have reached.
Why don't you submit a default judgment?
The parties have actually, we'll submit a default under the 7-day rule. We did reach an agreement with Ms. Dumas. It looks like we sent her a settlement letter instead of a consent judgment in error. So we've recently we sent her the consent judgment, looks like about a week ago. So we'll wait another week or so to see if we get the consent judgment back. She's already made the first payment. And then we'll either file the default judgment or the consent judgment. But as long as she keeps paying, we'll stick to the settlement that we've agreed to.
Beautiful, beautiful. All right, that works for us.
Thank you. Have a good day.
Thank you. You as well.
Okay, then the first one that's up is McFarland versus Loop Stop. And the other two left in the waiting room is another small case hearing.
Small claims, yep.
You want me to bring them both in?
Got them.
Thank you.
Hello? Can you guys hear me?
Good morning. You are Elizabeth McFarland?
Yes, sir.
All right, good morning. And
Good morning.
Mr. Stemmerich, you can hear us?
Yes, sir.
Okay, so today is the date and time set for a small claims hearing. Ms. McFarland has brought a claim against Lube Stop. What's your position with Lube Stop, Mr. Stemmerich?
Owner?
Okay, is Lube Stop Incorporated or an LLC or DBA?
Incorporated?
Thank you. All right, Ms. McFarland, today's the date and time set for you to convince me that Lube Stop owes you money.
Okay, I sent you in some more.
Ma'am, are you driving
evidence?
down the road right now?
Yes, I'm getting
Hold on,
ready to
are you
exit.
driving down the road?
Yes, but I'm getting ready to exit and
All
park
right,
in the
well,
parking lot.
You exit, we'll be back to you. Mr. Stemmerich, give me just a minute. I don't want her trying to do a hearing while she's parking.
Do you want me to bring in the other case, or do you want to find out who Chris PayPal is scheduled at 10:15?
All right.
Midland versus.
All right, Ms. McDaniel, Mr. Davis, can you both hear me okay?
Yes, sir.
Mr. Davis, you're muted. Can you hear me? Mr. Davis, you have to unmute.
Can you hear me?
Now I can, thank you.
All
All
right.
right, today's the date and time set for a small claims hearing. Mr. Daniel, this is your opportunity to convince me that Mr. Davis owes you some money, understood?
Yes, sir.
Okay. Are you ready to get started?
Yes.
All right, I'm
So,
gonna ask both of you to raise your right hands. Do you two swear or affirm, tell the truth, the whole truth, and nothing but the truth today?
I
Yes.
do.
Thank you, Ms. McAllen. You can get started.
So in
You put your hand down,
2019,
Mr. Davis.
2019, Brandon and I agreed that he would claim the kids for the taxes and that he would give me $3,000 for claiming the kids. We had separated already, and I had been asking Brandon, has the check come? What's going on? Brandon told me no check came, so I went online and found the information because I knew how much that we will be receiving at the time. I went online and found that he had the taxes deposited in his account in October of 2020. And, I was calling and asking him, and he just led me on saying that he never gotten anything. I have text messages between us about, this tax issue. Basically, Brandon ran off with the money and told me I'm not getting anything, but he didn't say it in that form.
All right, so it was for the tax year 2019, correct?
Yes,
All right, how many kids are we talking about?
2 kids.
And who did the kids live with?
They lived with me. Brandon and I had separated, going through a divorce.
No, they
Okay.
live with us. I also stay there too, sir. This is not the first time this has happened. This is like throughout our marriage, I always claimed the kids. So this is something that's just started. I always claimed the kids, and like she said, I always agreed to give her money, which I always did. Now, for some strange reason, when we get a divorce, she wants to come after me for some money. I have gave her money on several different occasions, even in these texts right here. Even in these.
Hold on. Do you two have a judgment of divorce?
Yes.
Yes.
Okay. Were these monies part of the divorce discussion?
No.
No, they weren't part of the divorce discussion. The thing was, we verbally agreed, things, because the divorce was over actually. Divorce had
When
been
was the
done and
divorce
over
over?
in
When's the
March.
Judgment signed.
Was March 10th or 11th, 2020, right before a pandemic broke out.
So the divorce was filed in March of 2020.
Yes, we
Right.
filed the tax. Yes. We had filed the taxes in, was it February, I'm sorry. I want to say the beginning of February.
Of 2020,
Yes,
correct?
that's for 2019, yes.
Okay. Did either one of you have an attorney?
No.
No,
Did either one of you have an attorney through the divorce?
no.
Okay. All right. And Mr. Davis, when did you quit living with Ms. McDaniel?
Wow. How can I prove that? Because when I stayed there throughout the time, my name was never on anything.
But you was receiving mail.
I'm just asking you when you moved out of the house.
I want to say, how long was I gone, Sharice? What, about a year before this? Or, it was a while. I mean, at least a good, was it in May of, that was so long ago, sir, I can't even lie to you and be honest and tell you, that was a very long time ago. Like I said,
But you moved out some number of months before the divorce was final, correct?
yeah, I was forced to leave. Yes.
Okay. And at what point did the kids stay with you and they weren't with Miss McDaniel?
That's what I'm saying. I always stayed with her because her name was on everything because she wouldn't let me put my name on.
Okay, let me ask it another way. Who are the kids with now?
I have my kids. These are my kids. These
All right.
aren't our
Have the kids
together.
ever? Okay. So at some point, Mr. Davis claimed your children, not his children, as dependents?
I don't have any. I don't have any children. Those were my children.
Okay. All right. All right. So there has never been a time when Mr. Davis had the kids and Miss McDaniel did not.
Right. I always stay. We always
correct.
We always lived together the whole 6 years, the whole
Okay.
5, 6.
All right. So if they're not his kids and they've never lived with him exclusively, why was he claiming them as dependents?
There you go.
Why was he claiming them? I mean, because we had always claimed them, and that's the same year, that we were still together. But he's always claimed them when we were together. It was like maybe a few months before then that everything.
Okay, but here's what I'm sorry to cut you off. Here's what I'm trying to establish. Has there ever been a time when Mr. Davis was responsible for your children's financial needs?
He will help out.
I was the power I was the power of attorney over her kids, sir.
You were the representative payee.
I was a representative payee.
Social Security. So he did help out because I'm sick. I'm like literally disabled, whereas I can't work. So he did help.
But right here in this text, right here, it's saying that you work, that you send
listen. Okay, I have a friend. I work for them.
But you just
every once in a while, maybe one day out of the week, and I'm just sitting there, watching his shop while he run errands. That's not really work if you think about it. I'm just sitting there.
I know, but that's what you said. That's what it says right
here.
Okay. I know what I told you.
So what Ms. McDaniel, what portion of the children's financial responsibilities do you think Mr. Davis took care of, and how much did you take care
of? Because they get like $294, they both were getting $294 a month. I would say I took care of the majority of it.
Okay. Ms. Davis, you said something. I'm sorry.
No, I was gonna let her finish. I was just figuring how can you say that when we together in the marriage? I worked the whole 5, 6 years. You never worked.
You're right.
How could that be?
I mean, because
I took care of I did everything I was supposed to do. I took care of everything. I provided everything. I did.
Okay, let me ask another question. Hold on. Let me ask another question. I'm assuming when you went through the divorce settlement, in the judgment of divorce, there was some kind of property settlement, yes or no?
No, sir. She tried to get the spousal support, which was denied. You
didn't have any joint assets or no, the judgment didn't cover anything about who would pay this bill or that bill?
No. I owned the car.
Your judgment of divorce just said you're not married anymore. That's it.
That's it.
Because Brandon would never come to any of the court appointments.
We didn't come to any of the court.
Okay. Ma'am, I didn't ask for an explanation.
Okay.
Look, this is not a chance for you two to argue. You want to do that? I'll get you out of my meeting. You can argue your little asses off. I don't care. But you're not going to argue with each other while you're on my Zoom meeting.
Yes, sir.
Fair enough?
Yes, sir.
Yes.
Okay. All right. So, Mr. Davis, all along while you were living in the house, you were claiming the kids and you were giving some of your tax credit back to Miss McDaniel. Yes or no?
Absolutely. Half of it. Absolutely.
Okay. So why should that change now that you're divorced?
Why should what change?
Why should you not give her back half of your tax credit? All the circumstances were the same during 2019.
I gave her that, sir. I gave her that money.
No, you didn't.
I gave her that money, sir. I gave her the money every year. Just like she accused me of taking the money for the stimulus check that I never received. I never got that. And I sent her proof. I sent her proof of
Okay.
everything.
All right, hold on a minute. Ms. McDaniel, are we talking about a stimulus check or are we talking about part of a tax credit?
It was
We're
two of them.
talking it, okay, Your Honor,
One at a time, folks.
we're talking about both. Okay, the taxes, which is 3,000. I never received any of that. And that's why I have text messages between me and Brandon asking for that. And the tax check, a stimulus check of $600. I've never received that.
Okay, and the stimulus check was received after your divorce was filed, correct?
Yes.
Okay, folks, here's what I'm gonna do. I'm gonna no cause this action. This is what happens when you decide to handle your divorce on your own with no legal advice. If you had financial situations between the two of you, it should have been part of your divorce before your divorce was final. Understood?
Yes.
Yes,
You saved money, you didn't have an attorney, and that's where it costs you. Have a good day.
We have Omar Najer and Chris Typale. It's Midland Credit versus Christopher Typale. You want me to?
You cut out, what's the plaintiff's name?
Plaintiff's name is Midland Credit.
Bring him in.
Good morning.
Good morning, counsel. We're bringing in Chris Typel.
Yep.
Trying to.
Hello?
Mr. Typel, can you hear me?
Yes, I can now.
All right, Midland Credit, your appearance, please.
Omar Najer, P 58066.
Thank you. Back in April, we were together on Zoom, and at that point, I thought we had a consent judgment, but we never saw any paperwork.
Correct, Your Honor. We mailed the consent judgment to Mr. Typel. He, if I recall, he sent us an email refusing to sign it, saying that was not what the agreement was. I don't know what the problem. I don't know. I'm not sure if he understood or what. Maybe he can explain himself. But essentially, we were doing, from my notes, it says we were doing a consent judgment, full amount, no cost or attorney fees, and no collection by plaintiff for 90 days. He was unemployed, trying to get approved for unemployment. CU Consumer was to contact us when 90 days approaches to see about extending hardship or setting up a payment plan. So that's what we sent him, a consent judgment.
All right, Mr. Typel.
You know, to that with those terms.
Mr. Typel.
The consent judgment was explained to me that it would have a written contract and a payment plan, and it didn't include that. I asked for that and I haven't heard back from them since.
Okay, well, it's not a written contract, it's just a written agreement between the parties. That's the consent judgment itself is the agreement.
Okay, he explained to me that he had more power than anyone I had previously talked to and could get me a written payment plan on the judgment. So I expected to see that. Every judgment like that I've ever seen had a written payment plan on it.
Okay, well, just so you know, all consent judgments don't have payment plans.
And at the time you said you couldn't afford anything because you're unemployed.
Well, you made it sound like the 90-day state elections was a 90 days for that to get worked out.
Well, we can try and work something out, but
Okay.
I was trying
Are
to
you
help
prepared
out.
to make a payment arrangement? Mr. Typel, are you prepared today to make an offer of payment?
Absolutely. I mean, I can afford $20 a month currently until I'm employed again, and then it can be more.
Okay, so why don't we do it for $20 a month for 90 days and then review it then?
That works for me.
Judge,
counsel?
I'll be honest, I'd rather not stipulate to that, but if you want, I will. But I mean, the judgment is like $7,000. But if we set up a review date, I guess right away, you can do that today.
Well, you were willing to do, yeah, but you were willing to do 90 days with no money.
Yeah.
This way that you're at
Yeah.
least gonna get $60.
Yeah, yeah, no, that's not the problem. Problem is I don't want it to.
You cut out.
For 90 days, that's great. I just don't want it to get lost in the just paint. I cut out. No, I see
All
you
right,
again.
your
I don't know if you
audio's,
can see me.
your audio's cutting out. Mr. Nader, your audio's cutting out. Are you saying you don't want to get locked into $20 a month?
Right. I just want to make sure if we can get a review date set, set for sure.
Absolutely.
Okay, that's
Put it
fine.
right in the consent judgment. And I think, Mr. Typel, you would agree that we're gonna set it up. It's gonna be $20 a month for 3 months, and after that, we'll figure it out. It might be more, it might be less. It
That's
might be all
I've
at once, depending on where you're at.
That's all I've been asking for nearly 2 years.
So in essence, yeah. So in essence, you're gonna agree that you do owe the money. It's not gonna cost you more than $20 a month for 3 months, and then we're gonna look at it again,
Yes.
right?
Yes. sir.
Okay, let's try it again then.
Okay, when is the first payment gonna start, Mr. Typel? You want it to start in a month?
Yeah, in a month. That's okay.
That's fine. Why don't we just say July 1st? And then July, August, September. And sometime in September, we can review it to see, right after that. Is that okay, Judge?
That
Yeah.
sounds great. We get
Alright,
something
is it-
on paper that way.
Okay, does the court have a certain day in September you want us to put? For your civil docket, we can.
No,
have
you,
it?
you can just schedule that with civil clerks. Civil clerks can actually put you right on the docket if you want.
Okay, all right, I'll have my paralegal, before they generate it, we'll put some date in there for sure, for certain. I think that's what you said, because you broke
Okay.
up too. All right, and then Mr. Typel, I still have your,
Yeah,
email
I'm having
address.
bad audio today.
Yeah, but, Mr. Typel, I still have your email address. Once we get the date from the court, we'll send you another consent judgment. I forgot, were you able to print it and sign it and send it back to us?
I can.
Okay.
Yeah, if this one is right, I will.
Yeah, okay, I just want to make sure some people can't print,
Right.
or scan and send back, but you can print and scan and send back so we can get it to the court. So they
No
can.
problem.
Okay. All right, so we'll put $20 a
Good
month,
luck.
July 1st, 3 months.
Gentlemen,
All right, thank you, Judge. Oh, you broke up again. Are you there?
yep.
All right, are we free to leave?
Have a good day. You are. Galaxy phone, what's your name?
He's not connected yet. I've been trying to chat with him, sending him instructions on how to connect. Do you want me to bring in Mr. Stemrich? Oh, you're doing that right now.
Just did.
Thank you, Judge.
All right, let's try this again. Ms. McFarland, this is your opportunity to convince me how much money, if any, that Lube Stop owes you.
Okay, I took my first oil change on here March 12th.
All right, ma'am, I hate to do this to you, but your audio is very, very garbled.
Okay, let me see. Can you hear me now, clearer?
I can. Yes,
You
I
said you
can.
can? Oh, yeah. I took my vehicle in to get an oil change at the shop. I had been taking my old car, my Ford Fusion, in there. So I took my new car in, and I got the oil change. The pandemic hit, and I'm a nurse, so I end up being suspected to have COVID. So I was told to quarantine, and that is why I sent you those letters from the hospital and the doctor. So I didn't drive the vehicle for I think like maybe a couple of weeks or so. And then when I drove the vehicle to go back to work, all the oil leaked out and the vehicle stalled on the freeway. So I had the vehicle towed to the dealership where I purchased the car at. And when I got there, they tried to pour a bunch of oil in it and get the car to start, but it wouldn't. And they gave me a letter stating what happened to the vehicle. It say the vehicle was towed in, and the inspection was done, and the oil filter was 2 turns loose. No oil on dipstick, oil all over the undercarriage. Was able to free it up, but it will need an engine oil. It will need an engine. Oil spill out of the filter side due to being loose. Whoever changed the oil did not tighten the oil filter properly. So I went up to the shop to let the owner know what was going on. And he told me that he understood, but he could not help me because the vehicle that is on the receipt is not the same as the vehicle that the engine blew on. But the mileage that's on the receipt for that day that I got the oil change is the same exact, around the same exact mileage as I sent you another paper in from
Okay,
the
let me
dealership.
stop you, Ms. McFarland. Hold on, let me stop you. Anything you sent to the court doesn't count. I don't look at the file because I don't know what information you might want me to review that Mr. Stemmer might have an objection to. So whatever documentation you want me to look at, we have to talk about that today. Mr. Stemmer has to have a chance to look at it. We discuss whether or not it's admissible evidence. You understand how that process works?
Mm-hmm. Yeah.
Is that a
Okay.
yes?
I sent you guys. Yeah. Yes. I sent
Okay.
both of you guys the documents. Okay. Yeah. I sent both of you guys the
Okay,
documents.
so
Mhm. Did you want me to finish?
go ahead. I just want to make sure you understand. I'm not reading the file as we go along.
Okay.
That's not the way evidence works. So
Okay,
if
I'm
you've
sorry, I
got a
don't know.
letter that you want me to consider, first make that letter clear to Mr. Stemmerich so Mr. Stemmerich can tell me yes or no. He agrees that I can read that or he doesn't agree. If he doesn't agree, we'll talk that through.
Oh, okay. So the letter that the letter that I want you to read is the purchase agreement from the dealership for the Chrysler. From the dealership where I purchased the Chrysler at. I sent that to both of you guys.
All right,
It has
what's the date
odometer
on that letter so Mr. Stemmerich can find it?
Okay, just 1 second, okay? Okay, the date is 3/6/2020, Livonia Auto Sales.
All right, Mr. Stemmerich,
I don't know.
take a minute, see if you can find that letter.
This one? Is that the one you're talking about? Are you talking about the letter?
No, that is
or the?
okay. That letter was the letter I was talking about, stating the oil leaked out of the car when I took it in, the evaluation that they gave me. This is the letter proving the mileage.
This one?
Okay.
That's it, probably.
Yes, sir. Yes, sir.
Okay.
Yes, sir.
I'll say, so there's two documents from Livonia Auto Sales, correct?
Yes.
It's a letter stating what happened to the vehicle.
Okay, hold on. Mr. Stemmerich, do you have any objection if I look at either one of those letters from Livonia?
No, Your Honor.
All right, that makes it easier. So let me find those and review those.
Okay. Not working.
All right, I see a lot of receipts. I see something from, all right, here we go.
We also, I need
All
to
right,
also have,
I see one thing from Livonia. I've
okay,
only got
it's
one
two,
document from Livonia.
the other documents were sent with
It's-
the other court date that we had. So they were sent before this one.
All right, I've got one that's a letter dated April 22nd.
Yes, sir.
Vehicle towing, customer stated vehicle shut off on highway. All right, so I've got the letter from William Van Trest that talks about the loose oil filter. And then the other document I've got is some kind of a form that
Yeah,
shows a
the
2010
Michigan
Chrysler
Department.
two-door with an odometer reading, 87,430.
Yes, sir. And then this, I will need
Okay.
the oil change receipt from the day that I got the service on 3/12/2020.
I'm trying to find that.
Okay.
I've got a conventional oil change receipt. I don't see a date on it anywhere.
It's on the top.
Oh, I got it.
Under
3/12 at
okay.
11:51. Yep, I got
Okay,
it.
and then
I got it.
and then
Okay,
one.
go
Okay,
ahead.
and then one more oil change sheet. 1/06/2020.
Okay.
Okay. Now those are the documents that I need to explain right now. If it's okay with him, because we added two more.
Okay. Mr. Stemrich, any problem with me looking at the two oil change receipts?
No objection, Your Honor.
Thank you. Ms. McFarland, go ahead.
Okay, so when I went to talk to the owner about it, he said, I understand, but I can't help you because the car that you're claiming the oil change, you know, that the filter was broken on is not the same mileage. So here's the receipt that has 1/06/2020. That shows that I used to take my Ford Fusion there, and you see the mileage is 256,000 miles because it was a 2007. And then if you look at the receipt from the from the Chrysler that I took in to get the oil change, you see the mileage 87,652, but he has the old car listed.
Right.
And then if you can look at the receipt from the dealership for the Michigan Department of the title registration, you see that mileage, it says 87,430, which proves that it was the Chrysler that he changed the oil on. And he just did not change the name on the receipt. So yeah, he just didn't change the name on the receipt because his problem was that he was saying that he couldn't prove that I brought in the Chrysler, but this is proof that there was the Chrysler that I brought in that the oil was changed on.
All right, anything else at this time, Ms. McFarland?
Just 1 second. Yes, hold on a second. I got so much paperwork on my lap, sorry. Okay, also it is another receipt from the junkyard. It is from A&K Towing Services. The date is 3/6/2020.
receipt from the junkyard?
I'm sorry, sir. When you're speaking to me, I couldn't hear the first words.
Have you seen the receipt from the junkyard, A&K Towing Service?
Yes, sir. You're free to look at that. No objection, Your Honor.
Any objections if I look at that? All
No,
right.
sir.
Ms. McFarland's that document supposed to show me?
That document shows that the date is 3/6. The Ford Taurus had broke down, which is the reason why I brought the Chrysler. It was already with the junkyard, so there was no way that was the car that he changed the oil on. Because the tow yard had already towed it from Dave and Buster's. And they purchased it as a junk vehicle.
And what's the amount of your claim today against the lube shop?
It is, I believe it is $3,850. And there is another, the purchase agreement that we just was talking about, tell you how much I paid for the car. I paid, purchase price of vehicles.
Looks like the total delivery price was $3,700.
Right. Yes, sir. Yes. And then I sent you in some listings from car. I think it was True Car to show the prices of the vehicle. Actually, my car was lower mileage. I couldn't find that same exact thing, but I found something close to it. So the mileage on here may be a little higher, but it's showing it's cost way more for that vehicle, but I didn't pay that much for it. So I couldn't find anything even in my price range for what I paid for it. Everything was over.
What would it cost? What would it cost to put another engine in it?
I don't have anything for that because listen, this happened a year ago. The car is not. I live in Texas now. You understand what I'm saying? So
okay.
If he would have did something right away, we could have put an engine in, but I couldn't hold on to the car over a year. You get what I'm saying? With no engine.
I hear you.
Because of the pandemic, it messed up everything, and I wasn't able to get into court soon enough so I can get an engine in it and everything. I would have just been holding on to a car and paying at an apartment complex to have a car there, just sitting there.
Okay. All right. Anything else at this point?
It's a little. No, that's it. Thank you.
Mr. Stemmers, do you have any questions for Ms. McFarland?
I don't think so.
Okay, your turn.
My turn. Most of that paperwork was not originally provided for the mileage verification of the Chrysler and this and that. It was all just, he said, she said, at this point, probably we did change the oil on the Chrysler. I don't know, obviously, it's a year later and stuff, but.
Let me stop you. I'm getting a lot of buzzing noise. And I don't know if you two are hearing it or not.
I got a fan on. Give me 1 second.
I'm hearing it really bad.
You know what? It's the fan on my laptop. Give me 1 second. Shuts off. Let me tilt it some. Let it cool down. Sorry, I've been here for 2.5 hours now. Anyhow, that'll probably stop. Basically, we never were provided an opportunity to inspect the car, anything of the sort. All we have is a letter from the dealer that sold her the car claiming that we broke it conveniently. I'm just at a loss here, really. We don't even know what happened to the car at this point. All we have is 6 weeks later, somehow the oil filter comes loose. I can tell you that if the oil filter were loose when you left my shop, you wouldn't have made it home. I mean, that's a fact. You can ask anybody. I mean, I don't know, but taking it back to the dealer and having them say that that somebody else broke the car isn't an inspection. It's not a mechanic. It's not, I have insurance for stuff like this even. I mean, the first thing they do is they send out a third-party inspector. There's 100 different things that can happen inside an engine. I mean, I can't buy a car just based on the fact that you have a random receipt and you're saying that 6 weeks earlier we changed the oil and left the filter loose. It just, I just don't really even know. At worst case scenario, the company needed an engine, which, I mean, I have working relationships with several shops. It would have cost $1,200, maybe $1,500 to put an engine in the car. You know, I mean, it's not a throw the car away situation or anything. I mean, I'm just at a loss with this whole thing. I really, you know, this is literally the
Mr.
I've ever even been to a hearing.
Let me ask you a question.
You know,
All right. Let me ask a question, Mr. Stemmerich. When is the first time that you knew that Ms. McFarland had a problem with the
I was approached.
Could you hear me?
I heard the gist of it. 6 months ago, probably, if I had to guess. It was long after everything. We didn't hear anything of it for months and months and months. And then she tried to blast us on Facebook and stuff. And they even said, hey, you don't have a receipt. You know, I mean, you got a receipt for a Fusion. She didn't, there was no purchase agreement shown, nothing. Just, they really, you know.
Okay. All right. Ms. McFarland, when was the first time that you let the lube shop know that there'd been a problem?
The first time I let him know was the same exact day that I got it towed. And I saw him up there and he told me he was not the owner. And come to find out he is. And he told me he could not help me because the car that I am telling him about was not on the receipt. And that's when I said, I'm just going to have to take him to court because I see he doesn't want to be honest. I know they have videos showing them changing the oil on a car. You understand what I'm saying? He can see that they did what they did. And the reason why he didn't find out until a few weeks later is because of the pandemic. We were told if you do not have anything essential to do not drive. And also, like I told you, I sent in receipts. I was suspected to have COVID because I was a nurse working during when the pandemic hit. And I was working at the nursing home in Plymouth. And what happened was everybody in there, we lost 50 residents died from COVID. So our building got attacked with COVID. So I wasn't driving. I'm not going to go outside and risk people's safety. I didn't move. Once I found out I had it, that's it. I stopped because I work with the elderly. And that's it. And then when I drove it, boom, I was picked up off the freeway. Car just, that's it. And the oil change stop is literally 1 minute from my house. So after I got the oil change and drove it home and parked it, that was it. You see what I'm saying? It's on the corner of my on the corner street of my apartment complex.
Right.
So I didn't have far to drive it at all.
Okay. Right. All right. Here. Anything else either one of you want to tell me right now?
No, sir. Not at this time. No.
Okay. I hate trying to do stuff on Zoom. I wish I could have you in my courtroom right now. So here's where we're at. This whole situation is all screwed up. Okay. And I understand, Ms. McFarland, that COVID put you in a box where you were quarantined for a period of time and so on and so forth. The problem I've got is I think it's very, very reasonable that the cause of your car problem was a mistake that was made at the lube shop. But I have to agree with Mr. Stemmerich. The way these things are supposed to work, once again, before COVID, is you have a problem, you let him know about it. He has his experts look at the car. You have your experts look at the car. You try to craft a resolution.
He told me no.
And I agree with Mr. Stemmerich. No. I understand that. I'm going to say it this way. You got off on the wrong foot. The original paperwork you showed him didn't seem to say that he did a car
I didn't show him that until court.
They had a problem.
I didn't show him that until court.
Okay.
I went up there before I had the paper. I took the receipt up there showing him he changed my oil that day. And he used the fact that it didn't have the right car on it and would not help me at all, and stated that he was not the owner. He stated he didn't even own the place, that his boss told him that.
Okay.
And you have
And I
to,
called Fox
but you have to
2. I
agree
called
that,
Fox
you know,
2 and
look at
everything.
like
did
Scott
show
up
it.
there, but I wasn't there, so whatever.
Oh, it was
But-
him.
Okay, Ms. McFarland, you would agree with me, would you not, that the receipt for the oil change actually shows it wasn't the car that was changed?
Yes, it does.
You had the oil change on a Chrysler, but the receipt for that oil change shows it was a Fusion. I understand that's probably a mistake made by the computer at
With
the
Chrysler
lube
miles,
shop.
with the
But
Chrysler miles.
right, but would you agree with me that just showing that to somebody
Uh-huh.
at the lube shop, it would show them that it might not have been the same car that the engine blew in?
Yeah, and he told me that he would first, when I took it up there, that's what he said. He told me he would get back with me. So when I went back up there, he said he couldn't help me at all. He said he took the receipt, and then he said, I'll get back with you. And I had to keep calling. But when I went, he said, I can't help you at all. But as you can see, that
Right.
Ford Fusion is a 2007. It's no way a 2007 got 80 something miles on it. It had 200 and something thousand miles on it. It was not the
Well,
same car, and it was already gone.
Hold on. I can guarantee that if Mr. Stemmerich has been in the auto repair business long enough, he has seen old cars with low miles. Those stories about grandma only drove it to church,
Yeah.
they do happen. So
Yeah, but that's why I have a
here's where
junkyard
we're at.
receipt. It was gone. It was gone already.
No, I understand it. I understand that. I don't disbelieve your story, ma'am, not at all. Okay, start with that. So here's what I want to do. I've got a bunch of other people waiting in my waiting room. Most of those are going to be quick fixes. So I'm going to put you back in the waiting room, the two of you back in the waiting room. Mr. Stemmerich, I want you to do some soul searching. I understand you shouldn't have to buy a car. I agree with you. But I do think there's some liability on the lube shop. I think COVID messed us all up all the way around. If nothing else, without COVID, she could have been in court sooner,
If she'd have provided this
a lot
paperwork to
sooner,
begin with,
and
I
we might have had a
suppose
chance to look at the car.
If this paperwork and stuff would have been provided to begin with,
sorry,
settle with the mediator, but none of this was here.
But
you told me you couldn't help me,
But
so
it's
why
been
would I give you
provided now,
anything?
so I want you to do some soul searching. Hold on. Let's not go backwards. I'm just gonna give
Okay.
you two some time in the waiting room. I'm gonna get back to you after I take care of some of these faster things. And I'm hoping that we can craft a solution that we're all unhappy with, but nobody's totally unhappy with it. All right?
Okay.
So give me just a few minutes.
Okay.
I'm gonna take care of some quick business and get back to you, hopefully.
Okay, thank you.
You're welcome, ma'am. Paula, you there?
I am, sir. Judge, we have
do you wanna
defendant
do?
Wilson. Sandy just texted me and told me that we have a defendant on the buyer's credit.
Your audio's cutting in and out.
Sorry. Sandy just texted me that the defendant on credit acceptance versus buyer's Wilson cannot get on to Zoom. He gave us his phone number.
Who's the attorney?
It's that Ms. Nonis. And we do have the attorney. She's on two cases, credit versus what buyers Wilson and Arbor Knoll versus Chatfield. We have Mr. Friedman, who's the attorney on Chatfield. And then if you want to contact Mr.
right.
Wilson by phone.
Bring in Mr. Friedman. Bring in Mr. Friedman. Ms. Notice on your credit acceptance versus Wilson file, we've got a phone number for him. He's called our civil department. He can't get on Zoom.
Okay.
So let's take care of Arbor Knolls versus Chatfield, and then we'll talk about Mr. Wilson. Maybe we can get him on your speakerphone.
Sure.
All right, appearances for Arbor Knoll versus
Good morning,
Chatfield.
Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
Good morning, Your Honor. Ellis Friedman on behalf of the defendant.
Good morning, you two. All right, so in February, we talked about possible mediation. Might have been a motion filed. So where are we at? Did we accomplish anything since February?
Well, Your Honor, I know originally opposing counsel was speaking with Tom Duquette. He had left our office, so I picked up the file. I had emailed him back in April, and Ellis, I haven't heard back from you. We can negotiate a settlement. I think settlement would be probable. I think we just need to get on the phone and chat, or maybe in a breakout room right now would be good.
I think the settlement is imminent, Your Honor. I don't think we need to get too worked up.
All right.
Neither one of us are worked up, I might add.
How imminent?
I think we just need to
You
exchange.
think you'll have it settled in a couple weeks?
Sure.
Yeah.
Why don't I put it on a no progress docket with the idea I'm either getting a settlement document from you or we'll just dismiss it because we don't hear anything.
Sure.
That's fine.
And then
How much
Ellis,
time
did
you
get
need?
my email?
I'm sorry, I didn't hear you, Ashley.
I'm sorry, I didn't mean to interrupt you, Your Honor. Did you get my email?
Yeah, yes, the offer.
Yeah.
And I conveyed it to Scotty, but I haven't heard back from him, and
Okay.
he's not predictable.
Yeah.
How much time do you need to work this out?
Let's say 3 weeks, Your Honor.
I'll give you 30 days. How's that?
Beautiful.
Good.
All right. Thank you, Mr. Friedman.
My pleasure.
Judge, I'm going to bring in 2 people to find out who they are.
Not bring them in. Go ahead. Counsel, I'm going to give you a phone number for Mr. Wilson. If you try to call him and get him on his your speakerphone, 313-482-5224. Who else you trying to bring in?
Vera Lewis. I'm not sure which file she's on.
That Galaxy just isn't connecting.
I hate to say it, but I think that might be Mr. Wilson, the one that you're calling. Okay. Come on, Vera.
Hello, can you hear me now?
Yes.
Yes.
Okay, I was pushing the buttons and it wouldn't work. Okay.
Miss Lewis, what file are you calling in on?
They sent me some papers for the Cash LLC, I think it is. For the one that was supposed to be resolved on, I was supposed to pay the $1,500.
I don't see it on the docket at all.
I got the papers right here, and I was like confused because I paid it, and I'm like,
Okay, can you give us
give us the case number?
Okay, give me 1 second here. Give me 1 second. I actually forgot about it in my alarm.
Please tell me you're not driving down the road.
I'm not gonna tell you I'm driving down the road.
You're muted, Miss Lewis.
Sorry.
You got the case number?
Yeah, 202846.
All right, we're gonna put you in the waiting room, try to find out what happened to that file.
We received a conditional dismissal, Judge, on 4/21.
So she doesn't need to be here at all today, right?
No, no.
All right, we'll let her go. Thank you.
Mhm.
I'll bring her back in and let her know.
Now you won't.
Okay.
Let's take care of Miss Nunes first.
I'm back.
All right, hang on.
Miss Nunes, did you get a hold of Mr. Wilson?
Yes, Mr. Wilson is with me on speakerphone. Mr. Wilson, can you hear us in the? Can you hear me, Your Honor?
Hello?
There you go. Mr. Wilson, do you happen to use a Galaxy phone?
Pardon me?
Are you on
What
a
type of
Galaxy
phone are you
phone
using,
trying to
Mr.
connect to
Wilson?
Zoom?
I'm sorry, it's doing. What did you say?
What type of phone do you have, Mr. Wilson? Do you have a Galaxy?
Samsung Galaxy?
A Samsung Galaxy?
Yeah.
Okay. Your Honor, do you have that on your screen?
Are you trying to connect on our Zoom?
Were you
I
trying
have
to?
a Galaxy, but I don't know if it's him.
Yes, I was. Yes, I was. There was no audio.
Okay. Okay. All right. So Mr. Nunes or Mr. Wilson, today's the date and time set for a pretrial. It's an opportunity for me to get some information about the file so we can move it forward towards resolution.
Okay.
Understood? Last time we spoke was way back in November. We adjourned the case for discovery. Counsel, where are we at from credit acceptance standpoint?
Well, Your Honor, my colleague is the one that typically deals with these CAC files, and he has a note in the system that the client wanted to dismiss without prejudice, but we were unable to get a hold of Mr. Wilson to sign a stipulation. So if he would be agreeable today on the record, we could do that stipulation, if that's okay with you, Your Honor, to dismiss without prejudice. Mr. Wilson, did you hear what I said?
Yeah.
Would you be opposed if we dismiss this matter without prejudice?
No, I would like that.
Okay. So, Your Honor, would it be okay if I submit
I
that?
agree.
Okay.
Absolutely. Just sign Mr. Wilson's name. He said on the record he's okay with it, so sign his name and submit it to the clerks.
Great, I will do that.
Mr. Wilson, do you have any
we're gonna
questions?
submit that to the clerk, okay?
Yes.
Okay, do you have any questions for the judge?
So it'll be over after today?
Yeah, we're gonna dismiss it without prejudice, okay? That means that the client may eventually bring it back if they wanted to, but the likelihood is unlikely. So we're dismissing this case and we won't have to appear back in court again.
Okay, thank you.
You're welcome. Have a good day.
You too, bye-bye.
Thanks, bye-bye.
Thank you, counsel.
You're welcome. I'll submit that
Thank
to
you,
you.
Ms.
Your Honor.
Nunes.
I didn't hear anything, so I don't know
Great.
what happened. I didn't hear anything.
All
Well,
right,
hang
Ms.
on a
Lewis,
minute.
can you hear me?
Yeah, I can hear you. Can you hear me?
Ms. Lewis?
Yes, I can. I can hear
We
you.
checked. Our civil department has received a dismissal from the plaintiff. They must have gotten your check.
Can
Got
you hear
that?
me? Yes, yes.
I can. Have a nice day.
Okay, you too. Bye-bye.
I'm sorry. We have Tracy Thomas as one attorney and Albert Kim, and that's on certified alignment versus Loma Trucking.
Good morning, gentlemen. Your appearances on certified alignment versus Loma.
Good morning, Your Honor. Albert Kim, P70.
Appearances, gentlemen, for certified.
Yes. Good morning, Your Honor. Albert Kim appearing on behalf of plaintiff in this matter, P70301.
Morning, Honor. Tracy Thomas, here on behalf of Loma Trucking.
Thank you, gentlemen. Looks like last time we talked was December. We adjourned for discovery. Where are we at?
Discovery has been completed, Your Honor. I spoke with brother counsel prior to the hearing. We think that maybe case evaluation would be a good option in this case. There's still kind of an impasse, and I think that getting something with teeth in it, as brother counsel put it, would be good to try to get this thing resolved.
Okay.
Totally concur, Judge.
Okay. Beautiful. I'm a big fan. So I'll just adjourn the file and give you fellas a chance to work that out.
Certainly, Your Honor. Does the court, do you know how long they're scheduling out on case eval right now, by any chance?
I don't. Sandy might have a better idea, but I don't have a clue.
We send it out to them and they'll send it back to us. We usually give them like 2 to 3 months.
Understood.
Do we need to generate an order?
The court will do that.
Great, thank you.
So we'll just set it up for a 90-day review. Let us know what's going on.
Will do, Your Honor.
Appreciate it, Your Honor.
Good luck, fellas.
You have a good
Thank
day,
you.
Your Honor. Be safe.
See
Be
you,
safe,
Albert.
Tracy.
Judge, once we finish this
Yep.
next case, then we're done with the docket.
Yep. All right, Ms. McFarland, we got you.
Yes.
Okay. Mr. Stemrich, you can hear me?
Yes, sir.
Okay, thank you. Anybody have a resolution suggestion?
Um,
Mr. Stemrich, anything?
yeah, I'm willing to offer the $1,500 that would have cost me to repair the car had any of this been handled properly. What?
All right. Ms. McFarland,
Um,
I'll be honest
sir,
with you. If I was,
okay.
go ahead.
I didn't know you. No, I thought you wanted me to talk. You go ahead.
I just want to let you know, as sympathetic as I am with you, with your situation, if I made a judgment today, I had already decided before I brought you back in that the most I could give you was $1,200.
Okay.
And once again, I believe your story 100%. That's not the issue. The issue is, and it's not your fault. It's not Lubestad's fault. It's just COVID, because this thing would not have gone down like this if it wasn't for COVID.
Yeah. I lost so much money because of COVID in different businesses.
I can't even imagine.
It's ridiculous.
I can't even imagine.
How they didn't pay customers. Yeah, I lost so much money because I had money in different places, and it's like these businesses are not. They don't care. Yeah, but okay, I hear you.
I don't want to go there, but
I'm just one man. I assure you, I've
there's a
lost
process that.
whatever.
Yeah, I mean, COVID hasn't been good for any small business people and most of their clients as well. So we can do this one of two ways. We can enter this as a consent judgment that just means you two agreed to the $1,500, or I'll just order $1,500.
What's the difference?
And I don't see any big difference one way or the other. One says that you guys agreed, and one says I made a decision. In your circumstances, sometimes I see where it might matter one way or the other. In this case, I don't really know that it does.
Oh, I would rather.
So, Ms. McFarland, why don't I order it?
Yes.
Why don't I order it? That way you don't feel like you voluntarily gave so much up.
Yeah, and I brought it.
Small
I brought
consolation.
it for my daughter. Yeah.
Yeah. All right, Mr. Stemrich.
I mean,
let's do. I've got your address on Crescent Clover. Is that a good address, Ms. Mark McFarland?
No, I moved to Texas. I sent you guys my new address. I can give it to you.
I think I have it here. 9123 Crescent Clover.
I've got a Crescent Clover Drive, apartment 2127.
Yes, sir.
All right. So Mr. McFarland, or excuse me, Mr. Stemrich will bring a check to the court. We'll send it to you.
Okay. Yeah.
Agreed? Mr. Stemrich, how soon can it happen?
I can mail it today, or I think, never mind, that's how it has to work. Never mind. I was gonna say I could Venmo her or PayPal or whatever to, avoid the delay, but I think, does it have to go through the court or?
No, not if it's all right with Ms. McFarland the other way.
Yeah,
I have Zelle. I have Zelle.
Yeah, what's that?
I have Zelle.
I can probably sign up for that real quick.
Okay.
How does that?
So what I'm going to do is I'm just going to make a note in the file that I've ordered.
Yeah, it's under my telephone number for Zelle.
Give me. Sorry, I just got to get a pen.
So Ms. McFarland, what I'm going to do is I'm going to order judgment of $1,500 paid within 1 week. So if you don't get the payment within a week, you contact us. We'll contact Mr. Stemrich and we'll get moving on it.
Okay.
What's your phone number, ma'am?
734
734
578
578
5250.
5250. Okay, I said that as soon as I sign up for the app or whatever, you'll have it within the hour.
Okay, thank you.
No problem.
Thank you, folks. Be safe.
You too. Thank you.
All right, thank you, Judge. All right.
Mr. Stemrich,
Yes, sir.
you still there?
Yes, sir.
I'm impressed. Thank you.
Thank you. Have a good day, sir.
You as well.